Good afternoon, everyone, and welcome to the webinar, Is the Wait Over? Details on Homeless Children and Youth in ESEA Reauthorization. My name is Barbara Duffield, and I am the Director of Policy and Programs for NAEHCY. My co-presenter, Patricia Julianelle, our Director of State Projects and Legal Affairs, was going to join me. However, she texted me about 15 minutes ago saying that not only did her house lose power, but their entire neighborhood lost power. So she is without electricity and therefore without Wi-Fi. So I will be doing the presentation solo today. For those of you who are not familiar with NAEHCY, we are a national membership association dedicated to educational excellence for children and youth who are experiencing homelessness from early childhood through higher ed. We have local homeless youth task forces across the country. We have many state higher education and homelessness networks. We have an early childhood committee that is very active. We both provide technical assistance on policy implementation, and we are very involved in policy advocacy at the federal level and also increasingly at the state level with state legislatures. We also work very closely with homeless youth and homeless families to build their leadership and to work with them in the support of all of our initiatives. Housekeeping questions. If Patricia were to be here with me today, she is our chat box queen and monitors the chat box and responds to them as she can. And then, what we don't get answered in the chat box, we try to respond to at the end of the webinar. Today might be a little bit different just because it's only me. So what I would ask is go ahead and put questions in the chat box. If we have time, I'll try to look at them at the end and answer them. If we don't, however, we will copy and paste the chat box. We did this webinar just a couple days ago and we had really great questions. So we're going to combine the Q&A from Monday's webinar with the Q&A from today's webinar and then post the questions and answers when we archive these webinars on their webpage. And we should have that ready for you by the end of this week, maybe early next week. So please know that one way or the other, we will answer questions. To our topic today, if those of you who are policy obsessed or policy wonks may know that today the Elementary and Secondary Education Act is being voted on in the House. So I'm going ahead and jumping right ahead to the last bullet simply because it is quite momentous. In fact, the U.S. House of Representatives just concluded debate and there will be a roll call vote at 6 p.m. Eastern tonight. I did not hear in my listening to the debate, I did not hear a single negative word. I think it is going to pass by a very wide bipartisan margin, and we'll know the actual count at 6 p.m. tonight. We know the details of the legislation because they were unveiled on Monday. So Monday morning, the final legislative language was unveiled, and before that, we knew that before Thanksgiving, the House and Senate had convened a conference committee to go through and really reconcile the differences between the two bills so that there would be a compromise framework. That passed before Thanksgiving. The language was unveiled on Monday. As I said, the legislation is on the brink of passage today, and we expect it to be taken up by the U.S. Senate next week. So right now, all signs point to a final bill to be sent to the president and signed by the president by the end of this year. So it's been 15 years since the last reauthorization, and we are certainly at quite a historic moment in education policy. We want to look now at what's in the final legislation. And again, when I'm saying final, I'm saying it's the final bill. It won't become the law of the land until the president signs it. So that was a question that came up on Wednesday. We kept using the word final, but this is not going to be actually the law of the land until the president signs it. And as you'll see later in the webinar, there are certain dates when certain parts of the legislation go into effect. Most of those will be for the next school year. But we want to go through the legislation and first with the specific amendments to the McKinney-Vento Act that were adopted, and then the amendments to Title I Part A. I also want to note that with this PowerPoint, you have the PowerPoint condensed version, which certainly doesn't get to all of the changes to the legislation. So also in the materials folder, in addition to this PowerPoint, you also have a fact sheet, a 6-page summary of amendments, which provides even more detail, some more specific language in more areas of amendment. Later this month, we will be providing an actual strike through, so if you want to see exactly which words were struck and all of that, we'll have that for you as well. So just know that right now you've got the PowerPoint and you've got a 6-page fact sheet, and there'll be more materials to come. So looking now at the category of amendments to the McKinney-Vento Act, specifically to the role of the state coordinator, the final legislation, the compromise legislation, requires that state coordinators be able to sufficiently carry out their duties. So looking at the capacity of the state coordinator by saying they must be able to carry out the duties that are spelled out in the law. State coordinators also are required to publish an annually updated list of liaisons on the state education agency website. Many states already do this, but it would be put into law with this legislation. Also, requirements for state coordinators to respond to inquiries from homeless parents, guardians, and unaccompanied youth. And also to provide professional development, including on certain federal definitions of homelessness. What the law actually says is that state coordinators shall develop and implement a professional development program that includes information on different federal definitions of homelessness. States have always been required to provide technical assistance, but the addition of professional development is something that is new to this legislation. Another item that is new is for state coordinators to post the number of homeless children and youth on the state education agency website annually. Again, some states do, some states do not, but this would be a requirement under the law, and also a requirement for states to conduct monitoring of local educational agencies. You'll notice with a number of these items, and as we go through the presentation, that a lot of the amendments to the McKinney-Vento Act are based either on current practice or best practice, or on expectations through the Department of Education that have already been set out or in guidance. So a lot of this reauthorization is not a radical departure, but rather what I would call a refinement and an incorporation of best practices into law. And that is certainly true when we look at the state coordinator amendments. Moving on to the amendments for local liaisons. The final ESEA legislation requires that local liaisons be able to carry out their duties described in the law. This too, very similar to the state coordinator, we want the legislation really pointing out that the person who has these two vital roles, state coordinator and local liaisons, need to be able to carry out their duties. The law, it doesn't go into more specificity as previous iterations of various bills talked about time. It doesn't get that specific, but just that they be able to carry out their duties. Another responsibility for the local liaison, that they disseminate public notice of McKinney-Vento rights in locations that are frequented by parents, guardians, and unaccompanied homeless youth in a manner and form that's understandable to those parents, guardians, and youth. Those of you who are liaisons may say, well, this is very similar to current law. In fact, current law does have a requirement for liaisons to disseminate public notice, but what the law says is that it would be disseminated in locations where services are provided under the Act. So this is really a broadening of the liaison notice, that they be in locations frequented, and also that it be in an understandable form. We know a lot of the literacy levels and the language may not be the same as, for example, the official posters from the U.S. Department of Education, so the law is intending that this information be accessible and understandable. Another addition for local liaisons is to ensure that school personnel who are providing McKinney-Vento services receive professional development and other support. Many liaisons are already doing this, so this too would be codified into the statute. With respect to local liaison training, where the final legislation landed is that state education agencies and local education agencies must adopt policies and practices to ensure that liaisons participate in professional development and other technical assistance activities as determined appropriate by the state coordinator. So this is new. State coordinators, as I mentioned, have always been required to provide technical assistance, but there was really nothing in the law that said that liaisons had to participate in it, and that now will be a new requirement. And the state coordinator does have some flexibility in terms of the appropriateness of it So for example, if somebody was just at an annual training, they would have the ability to perhaps waive a liaison from being at a new training, but the overall point of this amendment is to make sure that liaisons do participate in professional development so they do have the knowledge and ability to carry out their duties. I'm going to switch now to the category of school stability in the amendments in McKinney-Vento related to school stability. And you have here, again, a condensed version. I would encourage you to read the 6-page handout that goes into a little bit more detail about this. But in sum, if you look at this, you'll see, well, this is basically what the U.S. Department of Education guidance says we should be doing. So this may not be a departure for your school district, but it might be a departure for your school district. So first of all, school districts are required to make a determination about which school is in a child or youth's best interest to attend. And in making that determination, they must presume that staying in the school of origin is in the child or youth's best interest. So there is an assumption that staying will be in the best interest. That is new. The previous law had the phrase "to the extent feasible," which was very confusing because of what feasibility meant or didn't mean. So the schools will be making a determination starting from the premise of staying in the school of origin, also then to be required to consider student-centered factors related to the child or youth's best interest. And the law does mention some of those, like health and educational continuity. There are 4 or 5 factors that are specifically listed in the law. In making the determinations, school districts also are required to give priority to the wishes of parents, guardians, and unaccompanied youth. So a presumption of staying in the school of origin, a review of student-centered factors, prioritizing the wishes of parents, guardians, and unaccompanied youth. And then finally, after all of that, after making the determination, school districts are required to provide a written explanation if, after they make the determination, the district determines that either the school of origin or the school requested is not in the parent or youth's best interest. So there is a mechanism if that determination really argues for a change of schools. It would be a written explanation with the right to the appeal if the best interest determination really argued for a change of schools. A couple other pieces on school stability. The first one is an actual change to the definition of school of origin. This is to account for problems that came up in implementation under current law. As you know, school of origin is defined as school and not school district, which meant that students who were in feeder school patterns, who were moving from an elementary to a middle or a middle to a high, really lost their continuity with their peers. They lost their school of origin because they no longer had a school. That was the definition. So the amendment now to the definition of school of origin would include the designated receiving school at the next grade level for feeder schools when a student completes a grade level served by the school of origin. It's very important with this provision, just like with all of the other school selection provisions, that the determination of whether or not it's in a student's best interest to follow that feeder school pattern would be subject to the same process as best interest determinations, as any other best interest determination. So it's saying that, you know, because you're transitioning from middle to high school, you have a right to stay in the feeder school high school no matter what. It would be determined on whether or not that is in the child or youth's best interest. Another change to the law that has a big impact on school stability is a clarification around the provision of transportation for students who are no longer homeless, who obtain housing in the middle of the academic year. This law does clarify that when a student obtains permanent housing, transportation to the school of origin must be provided until the end of that academic year if it is in their best interest to remain in that school. This had been an area of difference of opinion with many state attorneys and other attorneys reading the law to require transportation to the end of the year for formerly homeless students if it was in their best interest, but the U.S. Department of Education taking a different position. Now that is clarified in this law so that there's really no question. If it's in a child or youth's best interest to stay till the end of the academic year, then transportation must be provided. Moving on to another category of amendments for McKinney-Vento, now we're looking specifically at enrollment barriers. And here too, I would call these refinements based on what we have learned over the past 15 years and incorporation of best practices. Current law, as you know, already requires homeless children and youth to be enrolled in school immediately, even if, and that's our current law. What was added to that in this reauthorization is even if a student has missed application or enrollment deadlines during any period of homelessness. So this will be helpful for students who are coming in and maybe wish to go to a charter school or another sort of school that has an enrollment deadline, but they missed it just due to their homelessness and they came in late. Schools would be required to account for that mobility and immediately enroll students, of course, who are eligible for that school or program. Also, state education agencies and local education agencies are required to develop, review, and revise policies to remove barriers to identification, enrollment, and retention of homeless students in school. And then you see the underlined words there, including barriers due to fees, fines, and absences. The underlined words are the words that are new. The requirement to develop, review, and revise policies about barriers to enrollment retention has been in the law for a very long time, but Congress with this reauthorization specifically is adding barriers to identification and also barriers due to fees, fines, and absences. You know, as I recall, back to 2000, 2001, when 1999, the whole reauthorization process then, well, there were I remember some liaisons saying to me, well, you know, that school uniforms are a barrier and we need to have that listed in the law. We had a whole conversation about how if we listed every single barrier to enrollment or retention in the law, we'd have a law that was extremely long. But at the same time, when issues keep coming up again and again and again, it does help to have some specificity. So every time someone asks me now about school uniform and or dress code requirement and I can point to it in the law, I think about that conversation. And I think the same thing is true with the fees, fines, and absences. We're actually going to have something, so rather than an interpretation of what it means to remove a barrier, we'll actually have some more specificity, which I think will be very helpful. Moving on to academic support and extracurricular activities, the new legislation would require states to have procedures to identify and remove barriers that prevent youth from receiving appropriate credit for full or partial coursework satisfactorily completed while attending a prior school. This, I would argue, is maybe there are many big wins in this legislation for homeless children and youth. This I would probably put in the top 5, for sure in the top 10, but maybe even in top 5, because we know that so many times when youth are going from school to school, they fall behind in credit. They so far behind that they don't graduate, they lose the incentive to go to school. So this is really modeled on legislation in California and other states so that we have ways to make sure that students do get credit for work that they've done elsewhere that was done satisfactorily and don't fall behind on their way to graduation. The second category related to academic support and extracurriculars, for states to have procedures to ensure that homeless children and youth who meet the relevant eligibility criteria don't face barriers to academic and extracurricular activities. And then I won't read the rest of it there. You can read some very specific sorts of academic activities that are listed. So again, we're looking at the broad mandate of McKinney-Vento to removing barriers, but with more specificity now, specifically around certain kinds of academic programs and extracurricular activities. It's also important with this piece to take into account the phrase, who meet the relevant eligibility criteria. So this is not saying that just because you're homeless, you know, you get to play varsity sports, or just because you're homeless, you get to go into a certain magnet program. It's saying that if you meet the eligibility criteria, then you must not face barriers to accessing that program. Next category amendment, looking now at homeless youth and college readiness. The first amendment here is 2 state plans for McKinney-Vento that now would be required to describe how homeless youth receive assistance from school counselors to prepare and improve their readiness for college. This is brand new to the law. This was an amendment that was added on the House side in the House debate. and will, I think, be of great assistance in even more closely engaging school counselors to reach out for homeless youth for college readiness. And in a very similar spirit, there's another amendment for local liaisons to ensure that unaccompanied homeless youth are enrolled in school, that they have opportunities to meet state standards, including through those procedures about credit accrual, and also that they're informed of their status as independent students for financial aid and may obtain assistance for verification for the FAFSA. We know already that many young people, if they fill out the FAFSA, they're much more likely to go to college. And for many homeless youth who may have not even thought of college as a possibility, to know that they can get financial aid and are assisted to get it will not only help with that transition to college, but also completing high school. So we're very excited to see the college readiness piece included into this reauthorization. With respect to preschool children, there are some important amendments in the legislation as well. This first one here is a modification of current law. This would require state plans to have procedures that ensure that homeless children have access to public preschool programs administered by the state education agency or local education agency, basically to have the same public preschool programs as other students. The change here that may seem pretty subtle, and it will be easier to read once we have a strike through of current law, is that Congress struck the word equal before access. So the intention there is to say that sometimes for homeless preschool students, equal access will result in nothing. There needs to be additional procedures in place to make sure that homeless children have any access to public preschool programs. So that's an important clarification. With respect to the liaison preschool responsibilities under current law and also under this law, liaisons are required to ensure homeless families and children have access to Head Start and Early Head Start and public preschool programs administered by the school district. But what this legislation adds to that is also that to ensure that they can access early intervention services under IDEA Part C if they're eligible. So the Head Start, Early Head Start, and public preschool piece stays the same, but there's an addition of early intervention, which also is very important for our children and youth who are eligible for those services. And finally, and perhaps most profoundly, with respect to young children, is another amendment to the definition of school of origin, which is that the definition of school of origin includes preschool programs. As Patricia and I have discussed, this is probably going to be one of the amendments that requires the most thought and guidance on implementation, because preschool programs do vary so significantly from state to state and even from school district to school district. So if you send us an email about how this is going to apply, we may not respond the very next day. I think we're going to have to put our heads together with the Department of Education and with our close partners at the National Center for Homeless Education so that we can give the best possible information. But essentially, what this does, which is very different from current law, is to say that yes, homeless preschool children do have a right to stay in their school of origin, and that would mean transportation. All will be subject to best interest, so this is not going to say you're 4-year-old on a bus for an hour. Everything with school of origin, we always come back to, it's all subject to that best interest determination. But if it is in the best interest of a preschool child to stay in their same preschool program, they now would have the right. So a critical recognition that stability is important, not just for school-age children, but also for younger children as well. Moving on now to identification. This was a major emphasis of this reauthorization. Congress really took to heart the report by the Government Accountability Office that discussed the under-identification of homeless children and youth and the challenges that liaisons have identifying homeless children, as well as other information provided to them about under-identification. So we didn't even list here all of the places where the word identification education was added to the law. Everything from the activities and services for grants, the purposes of grants, the list of barriers. Really, the legislation puts a strong emphasis on improving the abilities of school districts to identify children and youth who are homeless, because if we don't know who they are, then they miss out on the protections and services and on the education that they so desperately need. So this is sort of a global piece about improving identification efforts. Children and youth who are homeless who have disabilities, there's a broad provision in the legislation, a coordination provision that school districts must coordinate McKinney-Vento and special education services within the school district and with other involved school districts. Much of this may be happening, but there certainly have been challenges around some of the coordination issues. So this is just an extra emphasis that coordination needs to happen both within the school district and with other school districts who may be involved for children and youth who are both experiencing homelessness and who have disabilities. Privacy amendment. This was a provision that was in both House and Senate bills, so there was really no drama or surprise about whether it would end up in the final legislation. A requirement for schools to treat information about a child's or youth's living situation as part of their student education record, subject to all the protections of FERPA, of Family Education Rights and Privacy Act. We have had too many instances of perhaps overly aggressive attempts to verify residents, to contact landlords and other people, and that disclosure of a child's homeless situation then jeopardizes their housing and potentially their safety. So this provision here just is, again, it's a clarification of what's already in FERPA, that anything about a homeless child or living situation is subject to the protections of FERPA. The next category of amendment has to do with access to housing and HUD homeless assistance. This is not a change to HUD's definition of homelessness. That is another legislative effort in which we are strongly engaged. Many of you may know there's a legislation called the Homeless Children and Youth Act that would amend HUD's definition of homelessness. This amendment does not do that, but what it does do is state that liaisons are authorized to affirm whether children or youth meet the current HUD's definition of homelessness to qualify them for HUD homeless assistance programs. So why this is important is because although for the most part HUD's definition does not include families or youth in motels or in doubled up, there are some categories, there are some situations under HUD's definition where a family in a motel or a youth who's doubled up, those situations are covered. But they're pretty narrow and they require quite a burden of proof. So for example, an unaccompanied homeless youth or a family who's staying with somebody else, they would have to be able to show that they can only stay there for 14 days or less, that they don't have anywhere else to go, and that they have no other resources to go to another place. That's a hard challenge for a young person who's trying to stay quiet and doesn't want to get kicked out, who never knows how long they're going to be able to stay there. The same thing for a family. So what this would allow a liaison to do is to say, yes, I know this, I know their situation, I've been following them for a while, they meet this category, I will vouch for them. I can certify that they meet the HUD definition of homeless under that category or any of the categories of the HUD homeless definition. So that takes the burden off of the youth or off of the family. The same thing for families who are paying to stay in a motel, but they only have enough money for 14 days or less. Again, that can be a hard thing to prove, particularly if you've got day labor or you're collecting cans or whatever the families are doing to go from day to day. So one of the important things about this amendment too that I'll say is that the actual legislation says without further agency action by HUD. And what that means is that HUD will not be allowed to regulate. So HUD will not be able to say, oh yes, you're authorized to affirm, but you have to do X, Y, and Z. This is it. So needless to say, while it's not the amendment to the HUD definition that we seek and that is needed, it is an important step in increasing access to HUD homeless services. The next piece related to housing is just in addition to an existing liaison responsibility. Liaisons are already required to refer homeless families for basic services, and the legislation adds housing services in addition to those other services. Again, most liaisons are already doing that, so this is just an addition reflected by best practice and current practice. Big topic, authorized funding level. The current authorized level for McKinney-Vento is $70 million. That is current law. The authorized funding level is what Congress thinks to be the right size for the program. I want to say it's like a ceiling, but it's not really a ceiling because some programs get more money than what they're authorized for, but it's essentially the right size. Congress thinks ideally this is how much funding this program should get. So back in 2001, Congress said $70 million. However, Congress never provided that much money. Every year, the appropriators are the one who make a decision about how much money the program actually gets. So currently, the most money that McKinney-Vento has ever received is $65 million. That's the current funding level. For this legislation authorizes McKinney-Vento for $85 million for each of the fiscal years 2017 through 2020. And though that may seem like, well, so they have $1 million for each of the 15 years since 2001. Meanwhile, we know that the growth in child and youth homelessness is exponential and doesn't begin to meet the need. This needs to be seen within the context of the overall bill and our overall political and budget climate, which is this is a tremendous achievement for this legislation. It's a 21% increase over the previously authorized level, 31% increase over the currently appropriated level. And if you look at the overall bill and a number of programs whose funding went down or were smaller increase, percentage-wise, McKinney-Vento has the largest increase in the entire ESEA bill. So we are very grateful for our congressional champions, particularly U.S. Senator Patty Murray, for really pushing this issue. And moving forward, of course, we will have to work to make sure that that money gets appropriated. But I just want to put that overall context in place. So if you look at this and say, well, $85 million, what's that in the scheme of things? In the current political and budget climate, this is a tremendous win. Moving now to Title I, Part A amendments, state and local plans. We're going to look at the Title I amendments first at the homelessness pieces and then specifically with foster care. First looking at state plans and then at local plans. So for the state Title I plans, there is a new requirement for states to describe how the SEA will provide support to school districts to ensure the identification, enrollment, attendance, and school stability of homeless children and youth. There's still an existing Title I plan requirement to coordinate with McKinney-Vento, but this is an actual description for how the state will support LEAs for the identification, enrollment, attendance, and stability. In addition, moving on to the local Title I plans, the local Title I plans will need to describe the services that will be provided to support enrollment, attendance, and success of homeless children, including services provided with a Title I homeless reservation. So this is very similar to current law. The addition is the specificity around enrollment, attendance, and success, including with the Title I reservation. So both of them important, not a huge change from current law, but important nonetheless. Title I Part A, reservation of funds, and here we do have some significant changes. The first one is that all school districts that receive Title I Part A funds must reserve funds to support homeless students. The way in which this is very different from current law is current law says LEAs shall receive such sums as may be necessary to provide educationally related support services to homeless children who attend non-participating schools. The phrase "who attend non-participating schools" has been deleted from the legislation, clarifying that all school districts, even those that are all school-wides, will be required to reserve Title I Part A funds. Related in terms of the amount of the funds that are reserved and how they're used, Title I funds the reservation must be based on the total allocation of Title I funds going to LEA and must be reserved prior to any other allowable expenditure of transfers. Also may be determined based on a needs assessment that takes into account both the numbers and the needs of homeless children and youth. This is a may and not a shall. We wanted it to be a shall. It's one of the areas where we were, and I would say one of the few areas actually where we couldn't get any traction. So it's a may, but nonetheless, it's helpful to have it be in the law and not just in guidance, to say that it may be determined based on a needs assessment, and then to specify that the needs assessment would take into consideration the number of needs of homeless children and youth in the district. And then with respect to what Title I funds can be used for, the final legislation for ESEA takes what we have now and had in the last two budget bills, and it puts it into the statute. So we know the last two budget bills, the last two appropriations bills, have authorized that Title I funds be used for services not ordinarily provided by Title I to other students, including supporting local liaisons and transportation to the school of origin. That now is actually in the Title I statute. So it won't be any question of whether it's going to be continued from one year to the other in an appropriations bill. It's actually in the Title I statute. So that will be very helpful as well, and will allow school districts to continue to have that flexibility for where they target their Title I funds, the Title I set-aside funds as well. And lastly, with respect to Title I and state report cards, a requirement for state report cards to include disaggregated information on the graduation rates and the academic achievement of homeless children and youth in foster care. So this is new and also very welcome. And when we say disaggregated information, it means we're not saying homeless and foster are together. It means there would be a disaggregated state graduation rate for homeless students, a disaggregated state graduation rate for foster students, and children and youth in foster care, and the same thing for achievement. So this, I think, will help shine a light on the challenges that these vulnerable students have. And I hope also will, for the agencies who are not school districts, also engage them more in education, because we know that there's so much more that goes on in the life of a homeless child or a child and youth in foster care that contributes to their academic achievement. So it will be a very public part of our education, our state report cards, to have this information available. And I should also add that many states already have this for homeless students, and so it's not a tremendous stretch in terms of making it happen across the nation. Our last topic now is foster care, we put here a short. It's a lot of information, and I realize this whole webinar is a lot of information, but particularly with respect to foster care, we wanted to create kind of a short version slide and then go through it piece by piece. This is essentially, for those of you who've been following this reauthorization, this is essentially exactly what was in the Senate bill. So in sum, what the foster care amendments do, they create a new part of Title I assurances, both in the state and local plans, that provide all children in any stage of foster care proceedings with McKinney-Vento-like protections for stability and enrollment. The big question is always transportation. So under this, as you'll see, school districts are not required to provide school of origin transportation if there are additional costs, unless they're reimbursed by the child welfare agencies or agree to provide it. And again, we'll go over more in a little bit about what that means. And with those protections in place, the definition of the McKinney-Vento Act will be amended to remove awaiting foster care placement 1 year after enactment. So before I go in and sort of say a little bit more about how each of these pieces are actually spelled out, a little bit of context again here is important. The child welfare agencies in 2008, child welfare law passed that put new requirements and responsibilities on child welfare agencies for educational stability, keeping children and youth who are in foster care in their school of origin, immediately enrolling them in school. But there was nothing in education law that matched that exactly. And so in many cases, McKinney-Vento sort of became it. And we saw in many states awaiting foster care really becoming the way through which a lot of the foster care stability was happening, even when it really was not appropriate. Although both groups of children, homeless children and children in foster care, have so much in common in terms of their mobility and their trauma and the barriers that they face, one important distinction is that for children and youth in foster care, there is a state agency with legal responsibility who is determining when and where they move, and who does have the ability to provide for transportation. There is some authorized use of funding there, and there is an agency that's actually deciding where they live and how often they move. So their similarities are important, but the distinctions are important, and this reauthorization tries to recognize where those are the same and where they're different, and to create an appropriate separation. And I think as we go through the next slides, you'll see how the law does that. First of all, in the state Title I plans, the state Title I plans are required to describe the steps that the state education agency will take to ensure collaboration with the state child welfare agency to ensure the educational stability of children or youth in foster care, and specifically including 3 assurances. The first assurance is that foster youth are enrolled or remain in the school of origin unless a determination is made that it's not in their best interest. The second assurance is that the determination must be based on best interest factors, including consideration of the appropriateness of the current educational setting and the proximity to school in which the child is enrolled at the time of placement. And thirdly, that when a determination is made that it's not in the best interest to remain in the school of origin, the child must be immediately enrolled in a new school. So these are very McKinney-Vento-esque protections for school stability and school access, but they're for all children in foster care, so it won't matter who does or doesn't fit the definition of awaiting foster care placement. And importantly, it's part of a state collaboration at the state level to figure out anything more than what is said here, how exactly those determinations are made. The other point I want to make is with respect to the second assurance, the phrase appropriateness of the current educational setting and proximity to school in which the child or youth is enrolled at the time of placement. That is a verbatim match of what is in child welfare law. So it's not that Congress is saying, oh, there's different best interest factors for homeless and foster youth. It's saying we already have a law on the books for child welfare agencies. Let's create some reciprocity within education law so the 2 laws are really talking to each other. Also in the state Title I plan, now we get to personnel, if you will, state agency personnel. The Title I state plan requires the state education agency to designate a point of contact for child welfare agencies who will oversee implementation of the state education responsibilities. And it also states that that SEA point of contact may not be the same person as the McKinney-Vento state coordinator. So recognizing that this is a big job for both the state McKinney-Vento coordinator, and it will be a big job for whoever is the state education agency foster care coordinator. There are a lot of different agencies to coordinate with in both fields, and they really recognizing that those roles are separated by law in the Title I statute. Moving on to the local Title I plans for points of contact. Local Title I plans also must contain an assurance that the school district will collaborate with the state or local child welfare agency to do a few things. The first is to designate a point of contact if the corresponding child welfare agency notifies the school district in writing that it has designated a point of contact for the school district. So one of the questions that came up on our webinar on Monday is, could this point of contact for the child welfare agency be the same person as the McKinney-Vento school district liaison? The short answer is yes. There's nothing in the law that prohibits it in the same way that it would prohibit the state level person from being the same level person, but there's 2 important caveats to that. The first is that, if you recall, when we looked at the McKinney-Vento amendments, the local liaison must be able to carry out the duties that are specified. So it could be very challenging for a school district to assign a point of contact to somebody and say that they are able to carry out their duties, particularly because the state is also now responsible for monitoring that The second thing that's really important to notice is that this point of contact in the Title I statute for child welfare agencies does not have any legal responsibilities. Unlike the McKinney-Vento liaison, where there are 7, maybe 9 responsibilities listed, there are none in the Title I statute for the point of contact for child welfare agencies. This, as you may know, is was previous versions of the legislation did have a limitation for high needs school districts that the rules had to be separated, but that was not a battle that we won, to be frank. So we are keenly aware of the need, particularly in large districts or high need districts, for those rules to be separate. Certainly in small districts and rural districts, it could work quite beautifully to have it be the same person. And I know there are many places where that's the case, but in a lot of cases, that's not going to be true. And again, homeless children and youth don't have any other agency looking out for them. So this is going to be an intensive area for implementation. And lastly, with respect to Title I and foster care, to talk about those local, the local Title I plans and transportation. Local Title I plans must contain an assurance that the school district will collaborate with the state or local child welfare agency within 1 year of enactment to develop and implement procedures for how transportation to maintain foster youth in their schools of origin, when in their best interest, will be provided, arranged, and funded. So again, it's collaborative with the state or local child welfare agency. There is a time frame within 1 year of enactment about how school of origin transportation will be provided, arranged, and funded. But there's more detail on the who pays part of that. Under these local transportation procedures, first of all, they need to ensure that foster youth who need transportation to the school of origin receive it promptly in a cost-effective manner and in accordance with the child welfare agency's authority to use its funding to provide transportation. So there's a specific cross-reference to the child welfare agency's transportation funding within that section. And also that the local transportation procedures must ensure that if there are additional costs incurred in providing the transportation, school districts will provide it if they're reimbursed by the child welfare agency, if they agree to pay for the cost, or if both they and the child welfare agency agree to share the costs. So, you know, the additional rerouting a bus or whatever the smaller things, any regular transportation a school district would provide. But if there are additional costs for school of origin, then school districts under these procedures are required to provide it under these 3 circumstances here. And then to close out the foster care piece, 1 year after enactment, the phrase awaiting foster care placement is deleted from the definition of McKinney-Vento Act. If you happen to be in Delaware or Nevada, then the law basically says 2 years after enactment. And that is simply because those are the only 2 states that have a statutory definition of awaiting foster care placement, and Congress wanted to give them more time because they have a state law to change. So it would only apply to Delaware and Nevada. Everywhere else, 1 year after enactment, awaiting foster care placement is not in the McKinney-Vento Act. So we will have 2 parallel programs that hopefully we work together, just like we work with migrant education or other education programs collaboratively, but there is some real recognition of the differences for children who are homeless and for children who are in foster care, both the similarities and the differences. Other parts of the bill, just to go over quickly here, there's a section of the legislation called, it's the Title IV of the overall bill, is called 21st Century Schools, but within it there are different programs, including the 21st Century Community Learning Centers that we're more familiar with, but also the Federal Charter School Program. And under the Charter School Program, states that receive charter school grants will be required to work with charter schools on recruitment and enrollment practices to promote inclusion of all students, and very specifically including eliminating any barriers to enrollment for foster youth and unaccompanied homeless youth. So some specific language on homeless and foster youth within charter school recruitment and enrollment, which is very welcome. And also then within this category of what's called 21st century schools, it includes safe and healthy students, 21st century community learning schools, charter schools, and magnets. For any of those programs that are funded under that, unaccompanied homeless youth age 14 and older will be exempted from parental consent requirements for mental health assessments and services if the provider actively sought consent but could not reasonably obtain it. So some additional protections for unaccompanied homeless youth under that title of the legislation. When does this all go into effect? With the exception of the deletion of awaiting foster care placement from McKinney-Vento, the amendments on homelessness and on foster care go into effect on July 1st, 2016. So essentially they will be in effect for the next school year. And that means obviously a lot of work between now and then, but it's also gives us something firm to plan around. So it's the, with foster care, it's a year from the date of enactment, and obviously that depends on when the law is actually enacted, and July 1st, 2016 for McKinney-Vento and Title I Part A, at least the amendments to Title I Part A that I've discussed on this webinar. This next slide is not really relevant anymore. We had this slide in here on Monday, but the vote is the recorded vote. It may be happening right now. I was told 6 o'clock. I did watch the debate today, and it was a practical love fest. Everybody on all sides of the aisle saying how much this is a good thing, and so I don't think there's any more drama or suspense on the House side. We'll send an announcement out through our legislative list tonight with the final vote count, and probably change our call to action to focus on the Senate, even though there's not really any surprises expected on the Senate side either. We always want to be safer rather than sorry. So we may send an alert out there, but I think we're going to see a tremendous margin of bipartisan support when the final vote tally is done tonight in the House and probably next week. And I don't know then when the president would sign it, but everyone, all the people are predicting by the end of this year, by the end of 2015. Normally, under normal circumstances, if I had my partner in crime and trusted colleague Patricia, I'm seeing maybe there Patricia is on the phone. I'm going to just see if I can unmute the other Patricia and see if she's there. Patricia, are you with us?
As a matter of fact, I am with you, Barbara.
Yay!
I had a power outage at my house, which made the internet go out at my house, so I apologize for that, but I'm here now.
Oh, I am so happy. It's a lonelier world without you, and also a longer world. So, Patricia, would you like to handle the chat box questions, or do you have anything else to add?
Well, I don't have anything to add. Because I logged in late, I'm not able to see the chat box questions that came in before I logged on. And the ones that I am able to see are really related to current law more than the new amendments. So I don't think I really have anything to add from the chat box.
All right. Well, as I mentioned, what we did on Monday is we copy and pasted all the questions. We got some great questions, and we'll do the same. I will do this with the questions that came in before. I'm not a good multitasker, hence I kept the chat so I didn't want to get distracted by it when I was presenting. But we will copy and paste them and either respond to you individually via email and or include your question in our collective response. I also want to let you know about resources in case you're like wanting to know when is this actually going to get passed or the blow by blow. There's a legislative update link there. That's where we'll keep everything. And if you want to get the emails in your inbox, you can sign up on that on the sign up link there. And again, we send them out whenever there's something that's truly newsworthy. And just to let you know, we're going to create an entire new page of our website for reauthorization as we get sample procedures, as we get guidance, as we get tools where we can show districts that are already doing this that might be helpful for other districts to look at. We will have a whole page on our website, and of course, as I mentioned, we'll be working very closely with the Technical Assistance Center, the National Center for Homeless Education, so that we can provide information to you about implementation. And also just wanted to give you our email addresses so you have that information as well. So Patricia, is there anything else that's popped up in the last little bit?
No, thank you. Some congratulations and thank yous, and I guess we would just have to reflect that back onto all of our members, since all of our proposals came from you, and you were the folks reaching out to your members of Congress. So if you thank us, we just thank you right back.
Yes, everyone, this is 8 years of a lot of teamwork, so we're going to have to work just as hard to make it real for the kids that we care about.